they violated Uniform Superior Court Rule 4.1, which says that judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Georgia Code of Judicial Conduct Rule 2.9 prohibits ex parte meetings except for a narrow exception: scheduling administrative purposes or emergencies that do not deal with substantive matters or issues on the merits. Provided that, so we don't believe that it falls under the exception to begin with. Provided that the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication. In my view, the transcript reveals open discussions about you're going to testify, you can say you don't recall. They're basically walking through the procedures for laying the foundation for prior inconsistent statements. To say that that doesn't put that meeting with just the judge and the witness who has been sworn in doesn't put the state at a tactical advantage over the defense who's excluded, I don't believe that to be the case. Secondly, even if it falls under the exception, the judge must make provision to promptly notify and give the parties the substance of the ex parte communication and an opportunity to respond. We were not promptly notified. We found out through, I keep saying, doggedness and happenstance. I believe that's what it was. We learned about it, and then when we asked for an opportunity to respond, we were promptly greeted with an invitation to go to the jail for 20 days. So that was violated. The Georgia Rule Professional Responsibility Rule 4.2 regarding communications with a person represented by counsel. The state, it's the worst kept secret in this courtroom that John Melnick represents Kenneth Copeland. Worst kept secret. Everyone knew that. I knew that, and that's why I called Mr. Melnick.
Okay.
The state is somehow claiming that in this case where the world is watching, it's a huge case, that they did not know that Mr. Melnick was representing Kenneth Copeland, and they went behind Mr. Melnick's back and initiated conversations with Mr. Copeland. Let's be frank, all these gentlemen are facing RICO charges with overt acts going back to 2013. So this is not a case where Mr. Copeland could not possibly be prosecuted. He could easily be indicted. He could easily be indicted and put with the rest of the gentlemen who were severed off of this case and be in Rice Street right now. He was in legal jeopardy when the state was seeking to speak to him outside the presence of his attorney. From our perspective, that was a knowing violation of Georgia Rule of Professional Responsibility 4.2. Additionally, Your Honor, there's Bar Rule 3.3, candor towards a tribunal. Now, I can't flesh this out without Ms. Love taking the stand. I would love to ask her about it, but in the motion to grant Mr. Copeland immunity, in paragraph 12, I believe it is, they specifically stated that a member of the defense team had contact with Mr. Copeland, and that prompted him to begin to assert that he was going to exercise his Fifth Amendment right.
All right. I would prefer that, since there continue to be allegations back and forth amongst the lawyers, that we specifically get what is actually stated in there instead of, and I know you're not trying to misrepresent anything, you're trying to give it your best recollection, but let's get the actual motion and read the actual words, okay? got it somewhere.
Okay, yeah, I've got it right here, Your Honor, from Ms. Persifield's email to us.
I've got it. If you, I mean, if you've got it at hand, go ahead, but if you don't, I've got it now.
Okay, I'm trying to find out exactly, try to figure out where it was. Okay, paragraph 11,
Go ahead.
I'm sorry.
Paragraph 11.
Yes. And it says, Kenneth Copeland has been subpoenaed to testify in the above style case. Copeland is the next witness scheduled to testify in this case on June 7th, 2024, beginning at 9:00 a.m. On June 4th, 2024, and June 5th, 2024, investigators with the Office of the Fulton County District Attorney coordinated and arranged with Kenneth Copeland to provide Copeland transportation to court on Friday, June 7th, 2024. However, on Thursday, June 6, 2024, after an encounter with defense team members and members of the Fulton County District Attorney's Office, Copeland stated to an investigator and to an attorney with the Office of the Fulton County District Attorney that Copeland may attempt to plead the Fifth to avoid testifying against members of YSL. I can only speak for myself. I did not have any encounters with Mr. Copeland on June 6th. 2024. I don't believe that any of my colleagues did. I don't believe any members of the defense team did. I don't believe that what's asserted in paragraph 11, to my knowledge, I don't believe it to be the truth. If it is not the truth, and again, I would love to inquire, but Ms. Love would be a witness at that point. Bar Rule 3.3, candor towards the tribunal, would also have been violated. The reason I focus on the violation of these rules is because of the Ford case and the proposition that we can do something about this besides run to the bar. And that makes sense because it's ultimately if, and I say it did happen, and I say the transcript establishes that it did happen, and you have the transcript, Your Honor. We have in the transcript the state and Judge Glanville both asserting, both affirming each other that Mr. Copeland can essentially be incarcerated indefinitely until this trial is over, until the trial of the co-defendants is over. That, to me, is coercion. That's intimidation. We have other examples where Mr. Copeland is given what I would say incorrect legal advice about what his exposure is for these allegations and his potential criminal liability. That is coercion. That's trying to convince him to take the stand and plead so that the state can then impeach him with his prior inconsistent statements, presumably. Mr. Copeland, the act of him taking the stand as a result of those ex parte communications has prejudiced, has harmed all of these young men in court here today. So there has to be relief beyond bar issues for them. Your Honor, I'm not going to repeat everything in my motion. You have my motion. I know you've read my motion. But they have a right to a trial. They have due process rights. They have a right to a trial free of prosecutorial misconduct if that misconduct rises to the level of a due process violation. They have an absolute right to a fair trial and due process in front of a fair and impartial trial judge. They also have the right to be present at all critical stages of the proceedings, including, I'm saying, and I think it's fairly clear, that those ex parte communications talking about the witness under the Scudder case that I provided to the court before, that was a critical stage and they were unlawfully excluded. And of course, there's no way we could have acquiesced because we knew nothing about it ourselves. So those are all violations that have harmed these individuals. There has to be a remedy. I believe that the facts are there for you to consider disqualification of district attorneys in this case. And I think Mr. Steele is going to argue that further. But also, I believe that the facts are there under the Wilson case, as well as the State v. Jackson, 306 Georgia 626, Anderson v. State 285 Georgia Appeals 166, and Wilson v. State 233 Georgia Appeals 327. Wilson v. State 233 Georgia Appeals 327.
All right, and those are the three cases that y'all gave me a couple of days ago.
About goading. And the reason I cite to those cases, because it's not often, well, it would be never probably, that a district attorney or prosecutor is going to say, yes, I did this intentionally, I did this to goad. These cases looked at the egregiousness of the violation, the experience of the prosecutors involved. Ms. Love is a chief deputy district attorney in the office, head of the unit
All right.
that deals.
Can I interrupt you for just a minute? So all of this is in your motion, and if and when we get to that point, that would be an appropriate argument, but let's
Okay, well, that
pause
you
it
asked,
for now. I have it.
You asked where we are right now, and that's from my perspective, that's where we are right now.
All right. And I don't mean you can't argue anymore. I just mean
No, I understand.
the information about their qualifications is in your motion.
Yes, Your Honor.
All right.
Thank you.
Okay. And if Mr. Steele's going to argue as to something else, that's fine. But I had said a little while earlier that with regard to Ms. Love, your proffer about what Mr. Abadi might or might not have to say about Mr. Melnick's representation was not yet relevant. I think it is now relevant, and the proffer has not been accepted. So if you want to present evidence as to that, that would now be appropriate.
Thank you.
And I don't mean this very instant, because I'm going to hear from Mr. Steele, but we now know that is an issue. So you can go ahead and get him lined up.
Thank you.
All right, go ahead, Mr. Steele.
Your Honor, I would just like the court to consider the case that was announced to this honorable court by Attorney Shard. I emailed it earlier today to your honorable court's co-worker and all the parties. It's Ford Motor Company versus Young, and it was 322 Georgia Appeal, 348. It's in Division 3. 745 Southeast 2D299 2013 case. And what our second highest court wrote was, and I've given a copy actually to this court. And
Oh, yeah, I got the copy. I appreciate it. Thank you.
it's on page 8 of 9 of the copy I've given. It's on the right-hand side, first full paragraph. And it specifically states that in the center, and we have previously held that trial courts may disqualify attorneys for violations of the disciplinary rules. We held that the trial court erred in ruling that because sanctions for violations of disciplinary rules appear to be the exclusive province of the Supreme Court of Georgia, not of the trial court, it lacked authority to determine whether plaintiff's counsel violated 4.2 Rule 4.2 of the Georgia Rules of Professional Conduct, and therefore should be disqualified. We noted that the determination of whether an attorney should be disqualified from representing a client in a judicial proceeding rests in the sound discretion of the trial judge. So I'd just like you to reconsider your order, not disqualifying Ms. Hylton and Ms. Love. And you've inherited a case that has a lot of history, and a lot of it bad. And I put into my motion, I can go over it with the court, and I also attached the YouTube links. It's on July 10th, 2024. I also filed in case the link goes away, I filed on a thumb drive to preserve it. So that's with the clerk's office, and a copy was sent to the prosecution as well. But it started before, but an opening statement, I don't know if you've read it. So
I read your motion and I looked at the portions that you were talking about.
Hurtful. It's hurtful. And then as of last week, a new court comes on. It's almost like, a breath of fresh air. It's all new. And again, I'm hit with a motion by Ms. Love that was the fourth time the same thing's argued, talking about a duty that is intentionally and knowingly not followed through by me, and I owe it to her. And I saw your email saying, whoever wrote that, you come into court. I understood it.
I don't think Ms. Love did herself any favors with that.
Well, the favors have to end. I'm not trying to, I've never done this before in my history of living in a courtroom, but it's just not appropriate that I can't accept a proffer from a lawyer. I've never said that before. I've never uttered any of those words. So I'll leave it with you. My point is, it doesn't end. There have been no sanctions. It's been ratified almost. And it's from everything. It's just, I put in paragraph 2, just choice examples from my memory. But it is constant. There are great people everywhere in the courts, and they shouldn't be treated like this. So I'm asking you to disqualify, because it's just not, at some point, the message needs to be sent that this is not the state of Georgia, and this is not our bar.
All right, thank you. As I understood the gravamen of your motion that you filed since I've been the presiding judge to disqualify Ms. Love and Ms. Hylton, it was because you needed them as a witness, and that was the basis of my ruling. And in Mr. Shart's motion that is under consideration right now is a request, again, to disqualify them. And I know that I previously said, y'all, that's a matter for the bar. And when I was talking about that, I essentially meant the, and I don't want to call it bickering back and forth, because I'm not sure it's been back and forth to any large extent, but that kind of thing, the whatever it is that had been talked about before, that's what I was talking about. I will tell you that this court takes Brady violations very seriously. And I mean, everybody ought to, prosecutors ought to. And I am considering that right now. So rest assured that I am aware and have been aware that I have the authority if I choose to remove them.
Thank you.
So, all right.